Well, this is Lester Robbins, and this is the ABCs of Insurance. Today my guest is Greg Pope, and he's going to talk about the importance of correct estate coverage and the correct plan you need so you do not end up in a disaster at the time of death or at the time of when you're going into a nursing home. Greg, would you like to give some background information on yourself, please?
Sure, thanks, Les. I've been an attorney for in excess of 20 years, and we practice a wide range of law, and a big part of our practice is estate planning.
Okay, you want to give us a little background on your firm?
Sure, the law firm I started approximately 20 years ago. We have 6 attorneys and 4 offices throughout Western New York.
Okay. What we're going to do is we're going to review basically wills, long-term care, insurance, power of attorney, and healthcare proxy. And Greg's going to give a little explanation of what each one is. What is a will, exactly?
Actually, a lot of people think they know what a will is, but it's really a written set of instructions that carries over when we pass away. And if it's drafted properly, the instructions are given credibility with the executor in the courts, and the wishes of the deceased person are carried out.
Okay. What is power of attorney?
Power of attorney is another written document. It allows an individual to select another individual or individuals to act on their behalf if they cannot do it or in their absence.
Okay. Next thing is, what is like durable power of attorney?
Distinguishing that from a regular power of attorney, the durable power of attorney would survive the incapacity of the person that made the document. In other words, if you drafted a document called the durable power of attorney and then at some point became incapacitated because of a medical problem, you were in a coma, or heavens forbid if you had become incompetent, that individual now can act even though that event has happened in that person's life, whereas in the other situation where it is not durable, the power of attorney would lapse.
Gotcha. And then what is a healthcare proxy?
Okay, that is another written instrument, and that carries over when a person becomes sick. A healthcare proxy allows the individual to designate an individual to make medical decisions for that individual.
Okay, and the next 2 things on the topic are long-term care. That's basically nursing home care, where if you go into a nursing home or you have out care patient where you have help at your house where nurses come in. And the other one is life insurance, and that is used to help pay your estate taxes or help to pass on money to your people who are watching your kids or pass on money for your estates. Okay, why is it such important that people need estate planning and wills and insurance? For what's their main need? What's the big need of it?
Well, I like to think about being a good steward of the gifts that you've been given. In our lifetime, if we have been frugal or if we've made wise decisions, most people don't like to waste property and money. And the reason that we do estate planning is just that we want to be good stewards of the gifts that we've been given in our lifetime, and so that we can use them for obviously our own benefit, but also our loved ones, such as our spouse or children or other individuals.
Okay. Now, how does a good estate planning lower your probate costs?
Well, when you look at what is estate planning, you really have to look at the entire picture. What do the people want to accomplish? And I really think you are talking about different stages and different needs. You're starting with the individual that is single. Those needs are a lot different than the needs of someone that's married and has a spouse and wants to provide for their spouse upon their demise. In that situation, you can lower your probate costs by doing a little bit of advanced planning, and I'm thinking about specifically the joint titling of assets. That can be done such that upon the passing away of the first individual, the assets would pass directly to that individual, and there would be no need in that situation for a will or probate. And that does not mean that we don't need proper estate planning. It just means that given that situation where the assets are not that significant, perhaps, we would want to do joint titling. There are times where there might be significant assets, and joint titling would be a part of proper estate plan with a will and a trust and so on. So one way to minimize probate costs are through joint titling, and probate costs are the things that are necessary to administer that person's will to pass those assets on, such as fees for courts, fees for attorneys, also appraisals and taxes to the state and federal government. So we want to minimize those things. And so in that situation where there's a husband and wife, joint titling comes in handy. It might not work as well with someone that has children and wants to pass those assets down to a child. That's when estate planning becomes even more important. And then given the continuum of life, you know, usually after a spouse and after children leave the home, and as we get older, you know, it's unfortunate, but you know, life goes on, and one spouse might pass away before the other, and then our needs change altogether. So it's a constant changing process.
Okay. Mm-hmm. Next thing is, when you do your will, is it important to make sure who you tell you who your kids go to?
Yes, you definitely want your loved, your children to, you know, be in the care of someone that you have a lot of faith in and regard for. I think you're looking at two aspects there when you're talking about your children, who can properly supervise and bring them up the way you would like them to be brought up, and then also who can financially take care of those children. So you're looking at those two aspects when you're deciding who your guardian for your children should be.
Okay, let's look at the worst case scenario. Let's say I don't have a will. I'm married, I got 2 kids, and my wife and I die in an auto accident. We're gone, cease to exist. Mm-hmm. And we didn't set up a will, and we really didn't have, maybe we had a couple relatives that lived out of state. We wanted them to have the kids. We told them that over the phone. The state steps in and says, no, we're going to assign guardians of your kids to who we think is correct.
That is how it works. If you don't assign a guardian in a will, that's how it's done. You put in the will the individual that you would have as your primary guardian, and then if that individual can't do it or does not survive, you'd have a secondary individual named as a guardian. But if you do not name someone in that will, unfortunately, those children are now at the mercy of the court in making the proper decision as to who will be guardian. And a lot of times it happens where there are competing interests. In the best case scenario, you have one family member step forward that's responsible and takes on that role. However, there might be competing family members who are both interested in being the guardian of those children, and then in the worst case scenario, you might not have anyone requesting that role because of whatever reason, and there could be many, finances or health or something of that nature. That child then would have to be put into foster home, and that's not good either. So with advanced planning, you can assure your children will be in the proper hands and be brought up in the best scenario upon your demise. So you have to think about it beforehand, and I'm not talking about only from the standpoint that you're looking at who could properly bring up the child, but you also have to talk to the individual that you're selecting, make sure they agree, and then in addition, make sure that they can financially care for the child or children, and there's things that you can do to make sure that that individual, even if he or she does not have the money now, can have, if you are properly setting up your estate plan, enough money through maybe a life insurance policy to bring that child up so that their guardian can financially support that child. Mm-hmm.
So that's another key. If you do put them in the will, make sure you've got the assets, money set aside for the kids till they reach their 18th birthday. At least they can get to 18. Exactly.
You want to make sure. And a lot of times, you know, a younger couple, husband and wife, they have 2 children, and it's just natural that they wouldn't have a large estate as they start out, and even into their 30s. A lot of people don't. They've been spending a lot of their money on a home, on furnishings, spending the money on children, as they have needed those things as they came into the family, whatever it might be. Furnishings, new bedroom, medical costs, whatever. So I think that life insurance is a very important vehicle, especially to the young couple in their 30s.
Okay. Our next one is, how does good estate planning lower your taxes?
Well, the federal and state government want a part of your estate. That's the best way to put it. The tax laws right now provide for, a break up to $700,000, and it slides to a higher level over the next few years, up to eventually $1 million. However, if you have and are fortunate enough to have had excess assets and bring you up over $700,000, you want to protect that money, and there are ways of making sure that the federal and state government don't get more than the fair share to the estate, and those taxes can be 1/3 to 1/2 of the excess over that $700,000. So with some proper planning, you can avoid hundreds of thousands of dollars of tax on your estate.
So once again, you're coming back to good estate planning versus not doing any. Maybe you might just do a will and say, kid A is going to get this, kid B is going to get kid C, and charity is going to get this. And all of a sudden you come in and you have like an $800,000 estate, and all your taxes are done and said. Over half of it goes to the state and federal government.
Right. Just because you have a will that you may have done maybe when you got married and you saw the need with a spouse does not mean that you are done with regard to your estate plan. It has to be revisited, especially when each child is born. We need to look at that. And also as you get more assets and accumulate more, and that's just the natural event, you need to revisit that. And I don't see any reason why a call to your insurance rep and your attorney every couple of years can't be done.
So once again, when you get married, when you're single, when you get married, when you're your first kid, your second kid, then maybe when your kids are going into college, when you're about 5 years out from retirement, about a year from retirement, and then after retirement, make the appointment, go sit down, spend a half hour of your time, might save you $400,000 or $500,000.
Absolutely, and not only save you money, but also help your loved ones too, because you want to make sure that you're a good steward of those assets. And if, heavens forbid, you meet with an early demise, that the people that you leave are left the money in the best fashion, so that they're adequately taken care of, and they can, make their life a little bit easier and better. Because that's what we really are all out in. I believe that's our mission. Is to take care of our loved ones and ourselves, of course, first, and then our loved ones, and then if we are lucky enough when we pass away to have some money, to see that it's used in the best fashion that you think should be done.
That's good.